Welcome to another episode of PolicyCast series, where we decode the latest tax policy and regulatory developments shaping business decisions in India. When custom law requires imported goods to be for use for a particular purpose, does the law look at how the goods are actually used or at the purpose for which they were imported? A recent CESTAT ruling in the Dalmia case examines precisely this question. Today, we discuss what the tribunal held, what intended use means in practice, and why this principle could also have relevance for emerging issues such as BESS under MOOWR. To examine the ruling and its practical implications, we are joined by Manoj Mishra, partner and tax controversy management leader at Grant Thornton Bharat. Manoj, thank you for joining us today.
Thank you, Shilpa.
To begin, let's set the context for our listeners. The Dalmia ruling has generated significant interest because it touches upon a fundamental interpretational issue under customs law. So, what is the key takeaway from this ruling?
The central issue before the tribunal was whether imported capital goods must actually be installed or used in order to qualify for deferred duty benefits under the MOOWR scheme, or whether the intended use of those goods is sufficient. So the tribunal decision is significant because it focuses on the meaning of the expression for use. According to the tribunal, where a customs provision links a benefit to the use of imported goods for a specified purpose, the analysis does not always depend on subsequent or actual use. Instead, considerable importance must be attached to the purpose for which the goods were imported. In other words, the law may look at the intended use of the goods at the time of importation. The tribunal also drew support from broader Supreme Court jurisprudence, which has consistently recognized that the expression for use can, in the right context, refer to intended use unless the legislation specifically requires proof of actual use. To be honest, if we look at this, a draw can be parallel can be drawn with the separate credit rules or input tax credit rules under GST. Even there, they focus on intended use, not the actual use of any goods for availing input tax credit. So I think tribunal was absolutely correct while deciding that it is intention which is important, not the actual use.
That's an important distinction. The ruling seems to move the focus beyond a purely outcome based approach and towards understanding the purpose behind the import itself. With that foundation in place, let's discuss why this distinction matters in practice. So, why is the distinction between intended use and the actual use important from a customs perspective, Manoj?
See, the distinction has practical significance because a larger number of customs exemptions, concessions, and procedural schemes are linked to the purpose for goods are imported. If eligibility could only be determined after actual use takes place, business world would face significant uncertainty at the time of importation. Consider a situation where a company imports highly specialized equipment designed for a particular industrial function. If the law states that equipment should be for use in the activity, the benefit may reasonably be assessed based on actual and intended purpose of the equipment rather than waiting months or years for evidence of actual use. At the same time, the tribunal approach does not mean that a taxpayer's statement of intention alone is sufficient. The intended use must generally be supported by objective evidence. The evidence may include the technical specification of the goods, contract, project reports, engineering documents, purchase order, business plans, and other records that demonstrate how the imported goods are proposed to be deployed. So the principle is not that intention automatically guarantee that you are eligible. Rather, it is that intended use can be legally relevant consideration when supported by facts and where the statutory frameworks allow such an interpretation. So, just to say that you cannot bring in machinery required to manufacture, say, truck while you are manufacturing a car. So saying that I intend to use that machinery to manufacture truck at some point in time. So you will have to justify that how it was intended, how you are going to use that, or how you would have used that. So intention alone is not sufficient, but at the same time, if you are able to prove that it was actually required for your project, but in that case, actual use is not, which will be posing some kind of hindrance in importing such goods or goods for customers' benefit.
Well, that certainly highlights why businesses need clarity at the point of import rather than years later when actual use may be examined. It also raises an interesting question. Could this principle have relevance to the ongoing question of BESS eligibility under MOOWR?
See, if you recall my previous answer, I say that it is you who will have to justify that whether intended use it for a particular purpose which is allowed under the law. Okay, so here again the discussion is going on whether battery energy storage system or BESS, what we popularly call it, fall into that criteria or not. So BESS are playing an increasingly important role in India's evolving power infrastructure. However, whether it is eligible or not under the MOOWR scheme is currently under examination. The authorities are reviewing whether deployment of fully built imported BESS systems directly into domestic power projects align with the objectives and framework of the scheme. Industry participants are therefore awaiting further clarity. The Dalmia ruling does not directly answer this question. However, the discussion on intended use may provide an important analytical framework for evaluating its eligibility. If the relevant statutory provisions require an examination on how imported goods are intended to be used, then the analysis may need to extend beyond merely physical characteristics of BESS and consider its design, function, and operational role within a larger project. For example, describing a BESS merely as a system that stores electricity may not provide the complete picture. Its broader intended purpose within the energy ecosystem may also be relevant. As a result, factors such as project design, contractual arrangements, technical configuration, operational integration, and intended deployment would all become important in assessing whether the conditions of the MOOWR schemes are satisfied.
So that's particularly relevant given the growing policy focus on energy infrastructure and storage solutions in India. So while the ruling arose in a specific factual context, its implications may extend well beyond the facts of the case itself. Thank you, Manoj, for joining us and sharing an important update. So the key takeaway from CESTAT ruling is that where customs law uses the expression for use, intended use can be an important part of the eligibility analysis. And while the ruling does not determine BESS eligibility under MOOWR, the principle could become relevant as that question continues to evolve. That is certainly an area businesses will want to watch. We hope you find this discussion useful. Thank you so much for tuning in today. Stay tuned for more insights on tax, policy, and regulatory developments in India.